I am, comfortably in my little fishbowl world and hoping that we have 6% economic growth and the government will shrink and we never have to worry about it again. But then again, there is the Supreme Court, and we have Ilya Shapiro here to talk to us about it tonight. Thank you for coming.
Thanks for that introduction, Brian, and for having me, and thanks to Jennifer and the Steamboat Institute as well. I love to ski, and so any excuse I have to come out here, I try to take. This time I only have time for one night, so I'm just going to put in a few hours at Eldora tomorrow. Any of you are welcome to join me. Brian was going to, but he came up with some excuse about doing his taxes or something. This doesn't seem very conservative thought and policy-like to me, to pass up, your pursuit of happiness on the slopes in order to meet with a CPA or something like that. But I told him that I was going to shame him publicly in that way, and maybe that's why, to get back at me, he put me through a sort of physical challenge on the way to this talk. Or maybe that happens with all speakers. Maybe that's just a component of this monthly lecture series that you have to walk. I think he took me about 3 circles around all of town. It was like up several hills, and I think we noted every building at the university. And of course, I'm not wearing my ski jacket today. He didn't tell me to bring that. I'm just here in my suit. And anyway, so I survived. If I come down with pneumonia next week, I'll send you my medical bills. Also, it's unfortunate that there's no alcohol being served at this event. I thought an evening at this kind of distinguished, august lecture series. And besides that, it's kind of dismaying because I find that the more my audience has had to drink, the wittier I am. We'll have to make do without that. But seriously, it is an honor to be your token truth teller for this month. I know you're only allowed one a month here in Boulder. And so I guess anything to the right of Marx or Engels or something, I guess Bukharin would qualify. I'm a right deviationist of sorts from your normal orthodoxy. Well, look, if you don't follow the Supreme Court closely, if you're a normal person, your impression of Justice Antonin Scalia is that he was a conservative who was on the court for a long time. Fair enough. But the legacy of the first Italian-American justice is so much more than that. I met him a couple of times, just sort of in passing, one of these receptions where he speaks and then shakes some hands and things like that. I've exchanged words with him once. I was introduced by a Federalist Society officer who told the justice that I had played a hand in coordinating amicus briefs for the first Obamacare lawsuit, the case that became NFIB versus Sebelius. Justice Scalia looked at me, shook his head, sighed, looked down, and said, "Sorry about that." That's my one personal interaction with him. But professionally speaking, before Scalia joined the court in 1986, legal arguments over constitutional and statutory interpretation often failed to consider the actual constitutional and statutory text. That's no exaggeration. He really fomented a revolution in legal theory and jurisprudence in that way, not overnight and not by himself, but through the sheer force of will and logic of his prose. There really has been a significant change. I mean, I've seen old law school casebooks that didn't even have the Constitution printed in them. And legal opinions where statutes were used at best to buttress reasoning about legislative intent. Eventually, the Constitution made its way into Appendix H of these constitutional law readers, and then finally, by the time I was in law school, into the opening pages. While Scalia wasn't wholly responsible for the advent of originalism, the idea that a constitutional provision should be read by what it meant when it was ratified, or for the revival of textualism, that is, that when you're interpreting a statute, you look first to the statutory text, and if that's clear, that's the end point of your inquiry. But he was certainly their highest profile and most powerful expositor. Indeed, Scalia based his entire revival of originalism and textualism on the idea that judges are bound by the written text and aren't free either to impose their own views or try to divine some sort of mythic legislative intent, or for that matter, the intent of the founders. Some people think that originalism means trying to figure out what James Madison had to say about violent video games or the internet, or what Thomas Jefferson might think about the individual mandate or something like that. But no, it's not that. It's not trying to figure out what the founders had in mind. And what do their words mean? So you look at dictionaries, you look at the Federalist Papers, which explain contemporaneously what provisions mean and things like that. As Jonathan Adler put it, he's a professor at Case Western Law School and a blogger at the influential Bullock Conspiracy blog. Before Scalia, quote, justices had no reluctance to join an opinion suggesting that statutory text could illuminate congressional intent or the legislative history was inconclusive. We may still disagree about the meaning of the Constitution, often vehemently, but we're all originalists now, playing on Scalia's field, or at least paying lip service to it, as Sonia Sotomayor did at her confirmation hearings. Look no further than the competing opinions in District of Columbia versus Heller, the 2008 case that reestablished the individual right to keep and bear arms, where Scalia wrote this, possibly his most important majority opinion. He had a lot of concurrences and dissents and what have you, but this is certainly one of his top 5. But Justice Stevens, writing in dissent, was countering him on the same ground. They were both trying to understand what the meaning of the text of the Second Amendment meant, what the history was, given sources from the 18th century. That in itself is a victory. Plus, of course, Scalia went about his craft with unprecedented verve. As those law school casebooks began acquiring a more serious intellectual rigor, indeed as Supreme Court opinions began accumulating more rigor. It's not just the methodology, but compare an opinion from recent years, or even the say, 90s, with something from the 60s or 70s, and it's, forget the ideology or the result or how even they went about doing it, but now it's much more rigorous, scholarly, and so forth. But even as I said, these casebooks began acquiring more serious rigor, they also began filling up with Scalia's writings. At first dissents mostly, but then a healthy dose of majority and concurring opinions as well. I was not reading legal opinions before he joined the court in 1986. I was precocious as a 5th grader, but not that precocious. But in retrospect, it is easy, as I said, to see a step change from the early 80s to the early 90s. It's no coincidence that every law student now reads and relishes reading plenty of Scalia's writing. Agree with him or not, in any particular case, and I have my own disagreements as well, of course, he grasps the nettle. Indeed, his dissents often ended up carrying the day, as with early on in his Supreme Court tenure. In 1988, the case of Morrison versus Olson, which upheld the office of the independent counsel. That was a 7-1 or 8-1 ruling. He was the solo dissent. And that opinion, or that office, became so discredited that both parties in Congress decided not to renew the law, the independent counsel's office, a decade later. The problem there was with the separation of powers. That is, how can you have this kind of free-floating office that's not accountable either to the executive branch, the legislative, the Constitution doesn't provide, or something like that. This is part of the problem with a lot of the administrative state and various other so-called independent agencies that are a law unto themselves. But Scalia didn't just dissent with this, but he you could trace his illustrative manner to this one dissent. He talked about how here the separation of powers problem isn't buried somewhere or some sort of technical quibble that he has with the enabling statute. Here the wolf comes as a wolf, he said. That is, we all know the expression of a wolf in sheep's clothing, right? Where something is hidden, it appears to be benign, but actually is harmful in some way. Well, here, there's no hiding the ball. The wolf comes as a wolf. It's in plain sight, the constitutional defect that he was looking at. He knew that he was writing for more than the lawyers before him, and that the Supreme Court's reputation depended on the clarity and logic behind its rulings. Again, agree with him or not, and I thought he was hopelessly wrong on unenumerated rights, for example. That is, how does the Constitution protect rights that are not enumerated that are not listed in the Bill of Rights? Cases like Troxel versus Granville about the rights of parents to control the upbringing of their children, or Lawrence versus Texas about homosexual sodomy. And I thought he was too deferential to administrative agencies. Rather than taking kind of judicial control of the interpretation of statutes, I thought he let the administrative state get away with too much. Now, not as much as I'll discuss shortly as Judge Merrick Garland has. The difference there is, I think, that Scalia was less likely, especially in the last decade or so, to read ambiguity into a statute, because under the governing doctrine, which lawyers out there will recognize as Chevron, is an important case, as well as other doctrines about judicial deference to legislative acts or to administrative interpretations. Scalia was less likely to find ambiguity in the statute, and therefore, if you have ambiguity, then you just defer to the agency. But nevertheless, I think there were some issues there. Or in his faint-heartedness in his approach to originalism sometimes, as compared to Justice Thomas, for example. The case of McDonald versus City of Chicago, which extended the right to keep and bear arms, extended Heller to the states. The big debate there wasn't about the meaning of the Second Amendment, but about why and how does the federal Constitution protect you individuals against state violation of your rights. Some of it was kind of technical in the weeds. Is it the due process clause of the 14th Amendment or the privileges or immunities clause? Why does it matter if your right's still being protected? Well, because privileges or immunities is more textually faithful. And if you read everything into due process, this idea of substantive due process, which Scalia himself has excoriated on many an occasion, that is sort of limited by little other than whatever you can get 5 votes for at the Supreme Court, whereas there's more of a textual basis with privileges or immunities. Anyway, in that case, Scalia joined the plurality that went for due process, and Thomas, the deciding vote, went for privileges or immunities. Happy to get into if there's any of you who are really interested in the 14th Amendment. But anyhow, there was a method to his acerbic pen. It was not mere legalistic argle-bargle or interpretive jiggery-pokery, to quote 2 recent witticisms. Moreover, to say that Scalia was conservative is to misunderstand what that means in the judicial context. I'm sure his personal views were very much what we'd call socially conservative, and that he voted Republican. But it's hard to argue that he made his legal decisions that way. Take Texas versus Johnson, for example, which is a case from 1989 that upheld the right to burn the flag. Right? This is Scalia supporting the right of hippies to burn their flags. I mean, I'm sure that was celebrated here at Boulder. He hated that, but he felt that he was bound to the Constitution, the First Amendment bound him to rule that way. If you're going to be a good and faithful judge, he explained in a 2005 speech, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. Perhaps the best example of Scalia's going against his policy preferences would be in the area of criminal procedure. One would presume that a conservative of Scalia's generation would be a so-called law and order type, who's concerned about criminals getting off on technicalities. Well, there's been no greater supporter of those constitutional technicalities than Antonin Scalia. If you care about the Fourth Amendment right to be free from unreasonable searches and seizures, well, you look at his writings in cases like, I'll just list them so those of you who are lawyers, it'll jog your memories. Kylo versus Florida about thermal imaging, Jardines versus U.S. dog sniffing, U.S. versus Jones, GPS tracking devices. The Sixth Amendment right to confront witnesses who will accuse you, Crawford versus Washington, Davis versus Washington. Or the right to be sentenced based only on facts that a jury has found, Apprendi versus New Jersey, Blakely versus Washington. If those are your concerns, if you're a civil libertarian of that ilk, Scalia is your justice. On the other hand, in Gonzalez versus Raich, the 2005 medical marijuana case, I think Scalia went with the drug war over federalism. Raich is no small case. It pushed the scales from my eyes about Scalia, just as NFIB versus Sebelius did about Roberts. But that's not bad for a 30-year career, especially given the flag burning and criminal procedure cases that I think clearly went against his policy preferences. But anyhow, what now? On so many issues of individual liberty, whether it's the right to participate freely in election campaigns, whether it's the right to bear arms, whether it's preventing the federal government from commandeering state officials. That's a very important opinion that he wrote. Prince versus New York. The idea that the federal government cannot force state and local officials to enforce federal law or implement federal programs. You can bribe them and say, hey, states, we'll give you this money if you do our bid, but you can't force them. Or stopping the government from forcing people to violate their religious beliefs willy-nilly, like the Hobby Lobby case. Replacing Scalia with even a moderate progressive would mean the end. And many close criminal law cases align along principled versus pragmatic lines. So a centrist would be worse there than someone like Ruth Bader Ginsburg. We'll talk again, I'll talk about Judge Garland shortly, but that is precisely the case. He, I think, is much less friendly to criminal defendants than would a so-called radical left-wing person often might. Moreover, filling Scalia's seat with a progressive jurist, even a moderate one, means that there will be no further check on the sorts of executive abuses that have only increased on a president who thinks that when Congress doesn't act on his priorities, he gets more power to implement his agenda. Now, I'll tell you what, I carry around a pocket constitution in every one of my jacket pockets, and you'll have to take my word for it, there is no when Congress won't act, the president gets more power clause. It's not the way it works. It's been more than 80 years since a justice was nominated and confirmed before the presidential election to a vacancy that arose earlier that year, 1932 with that year. And it's been 100 years since such a confirmation had a recorded vote. Typically, justices were confirmed on just a unanimous voice vote. That was 1960, where Louis Brandeis was so controversial, in large part due to anti-Semitism, that the Senate Judiciary Committee had to have its first ever hearing on a Supreme Court nomination. It's not the case that we've always had hearings on nominees. That practice was started in 1916. Then they didn't really have them for a while again. The first time that a nominee testified at his own confirmation hearing, by the way, was Byron White in 1962. He was given 3 perfunctory questions and then was excused. Typically, for any positions, not just judicial nominations, you typically had people testify on your behalf, whether personal or professional references. In a decade when Barack Obama has won 2 elections and the Republicans have won seemingly everything else, the Senate is fully justified in not taking up any nomination until after a new president is inaugurated, as I'll discuss shortly. Legal pundits do try to make judicial appointments a focus in every election. I think, Brian, you were overly generous. I think we generally fail in making elections about judicial nominations. It would be great if they were, because American people have more commonplace concerns, such as the economy and national security. But Scalia's last gift to his beloved nation is thus to ensure that in this craziest of election years, the fate of the Supreme Court has indeed become the paramount issue. So now we have a nominee, Chief Judge Merrick Garland of the U.S. Court of Appeals for the D.C. Circuit. What do we know about Judge Garland, who's been on that court, which is often called AAA court, the second in importance, because it gets all of these appeals from federal agencies. He's been on that court almost 20 years. There's really not much there in terms of anything notable. I mean, he's a solid, workmanlike judge, takes great pains to craft his opinions, nothing extremely controversial, if you're not kind of getting into the weeds, legal scholar type. Tom Goldstein, who's the founder of SCOTUS blog, did a long and exhaustive essay reviewing essentially all of Garland's work in 2010, when he was also being considered for the High Court. That seat would eventually be filled by Elena Kagan. He had also been considered the previous year for the seat that was filled by Sonia Sotomayor. So I guess twice a bridesmaid, and eventually you get to become a bride. Although query whether, if it wasn't such unusual circumstances, whether Obama would have gone for a 63-year-old white male. But nevertheless, for a long-tenured judge on a prominent court of appeals, Judge Garland has written surprisingly few headline-grabbing or readily memorable, even for administrative law professors, scholars, opinions. He's participated in very few cases that resulted in Supreme Court review. I suppose that could be a good thing. If he's on panels or he himself is writing opinions that are correct, the Supreme Court doesn't feel the need to review. I suppose that's a good thing. But there were 7 such cases that the Supreme Court took up, and the justices agreed with him in 4 of those 7. Some areas or cases of note. There was one involving due process, kind of a curious case from 10 years ago. That's the issues comes up again now nationwide, state by state, the right to try drugs that haven't been fully approved by the FDA if you have a terminal illness or a reason like that. Garland there did not write the opinion, but joined the majority that rejected the claim of a constitutional right to access these unapproved drugs. There were 2 dissenters there, the Libertarian Judge Ginsburg, Doug Ginsburg, not Ruth Bader, who, of course, if you'll recall, is effectively the last public casualty of the drug war. He had to withdraw from his nomination that President Reagan made to the High Court because it turns out he had smoked pot with his students. And Judge Rogers, who's a liberal on the D.C. Circuit. They were the dissenters in that case. On the First Amendment, some people are thinking, oh, well, maybe he kind of has a conservative view of campaign finance because he joined the majority in a case called SpeechNow.org versus FEC that held that an association of individuals was not subject to restrictions as a political committee. But I think it's pretty clear that that case followed directly, had to follow from Citizens United, so he was, his hands were bound. And other First Amendment opinions, other campaign finance opinions, show that he does not really deviate from progressive expectations in that area. On administrative law, this is the area of you have the EPA doing something, or the National Labor Relations Board, the Federal Communications Commission, these alphabet agencies that implement the complicated statutes, that regulatory schemes that Congress passes. He, I don't think, has found a regulation that he hasn't deferred to, unless it was a kind of a deregulatory regulation of sorts. Just one of the most deferential jurists you can ever find. One such example was the use of the Endangered Species Act to protect the arroyo toad, which is a species of reptile that lives in kind of this local area in southeastern California, I believe. This case, called Rancho Viejo versus Norton from 2003, prompted John Roberts, when he was on the D.C. Circuit, to dissent, saying that the panel's approach in this case leads to the result that regulating the taking of a hapless toad that, for reasons of its own, lives its entire life in California constitutes regulating commerce among the several states. So, interstate commerce, right? How is it regulating interstate commerce to be regulating a toad that has no commercial value and that lives in one state? Criminal law, as I said, here he is not at all liberal or civil libertarian, has even tended to disagree with his more liberal colleagues on the D.C. Circuit. The reason that the D.C. Circuit sometimes has these criminal cases is because it also takes up white-collar and serious blue-collar crime from D.C. itself, geographically. So they do have occasions to take those issues up. On gun rights, on the Second Amendment as well, there are indications that he is not one of us, shall we say. He would have, he wanted to re-examine the D.C. Circuit's ruling that was the precursor to Heller, that had struck down D.C.'s gun ban. And on labor law, on environmental law, as I said, has generally overwhelmingly favored the agencies, so much so that the president of the National Federation of Independent Business took to the pages of the Wall Street Journal to talk specifics about how bad for business he would be given an activist National Labor Relations Board. But of course, this is not about Garland, really. Republicans have taken a staunch position not to consider this or any nomination. In fact, it's such a kind of staunch position that there's a hashtag associated with it. Those of you who are handy with social media know about hashtag no hearings, no votes. It's part of the branding, the marketing that you have to do to kind of activate your supporters and things like this. It seems to be working, surprisingly. I mean, I don't think anyone has ever made money betting on Republican senators having spines of steel, but we're 2 weeks after the nomination, and we have the expected cracks. Mark Hurt, probably the most embattled, most blue state senator the Republicans have. Susan Collins of Maine, who's the most moderate Republican senator, but certainly nobody on the Judiciary Committee. In fact, all members of the Judiciary Committee signed a letter to Senate Majority Leader Mitch McConnell saying we won't have hearings. And even other blue state Republicans up for re-election, like Kelly Ayotte in New Hampshire or Ron Johnson in Wisconsin, seem to be towing the line for now. But let's look at what the Constitution requires. Here is what Article 2, Section 2 says. The President shall have power to nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court and all other officers of the United States whose appointments are not herein otherwise provided for and which shall be established by the law. So, the President has the power, maybe even the duty, it says shall have power to nominate, maybe the responsibility, however you want to characterize that, to nominate, and then the Senate the power of advice and consent. So I don't think anyone can interfere with the President's power to nominate. But then the Constitution is silent as to what advice and consent actually means. And the scholars that have looked at this say, we have no idea. It's up to the Senate. And so historically, judicial confirmations, whether Supreme Court or otherwise, have been conducted in lots of different ways. As I mentioned, there weren't even hearings for a long time. And there are different circumstances in various times. The modern filibuster is a new innovation of judicial nominees. I guess we can look at parallels with bills that the House passes or treaties that the President signs. It's not like the Senate has to have a vote or a markup on these bills or on these treaties. Nobody accuses the Senate of violating its constitutional duty when it does that. So I think that the same thing is here, which means that this is really a political battle, which is what it should be. Because for good or ill, I think mostly ill, the Supreme Court is a powerful institution. And we have competing, irreconcilable views of how to interpret the Constitution, how to apply the law. And it's a big deal. So I don't blame senators for responding to political incentives. That's who they are. I mean, really, if you want to blame something for our poisonous confirmation battles, blame the Supreme Court itself in 1937, when after decades of rejecting federal overreach, it had the famous switch in time that saved 9, and the Supreme Court started ratifying a vision of constitutional law ever more divorced from constitutional text. That's why we have these battles, because obviously, especially when it's someone of Scalia's stature that dies in an election year, whose spot could turn the direction of the court in the ways that I've alluded to, that's a very important political argument to have. Which direction should the court be going? And I think it's best to defer the confirmation process for several reasons. This is only the third Supreme Court vacancy in the last century arising after presidential election voting has begun. That is, the primary season had started. Both the previous times, the Senate did not confirm a nominee until after the election. There was a recess appointment by President Eisenhower in 1956, and then the vacancy under President Johnson lay vacant until President Nixon took office. There was a vacancy for over a year, and there was a confirmation in 1969. The only time the Senate has ever confirmed a nominee to fill a vacancy created after presidential election voting had begun was 1916. And in that case, you remember I mentioned Justice Brandeis with the first ever hearing. Well, here, Justice Hughes resigned to create that vacancy to run against President Wilson, kind of an unusual sort of situation. We have to go all the way back to 1888 to find a year in which the Senate confirmed a Supreme Court nominee of the other party in an election year. And that's when a handful of Republicans joined minority Democrats to confirm Grover Cleveland's nominee, Melville Fuller. But of course, the court wasn't nearly as powerful as today, and the confirmation process was very different. There was the time of tall hats and bushy sideburns, very different. The judicial confirmation process has become increasingly combative, especially for the Supreme Court. I think it would be especially difficult and taxing in the middle of this weird, bizarre, contentious election. And as I said, President Obama's judicial appointees would be radically different, even Judge Garland, than Justice Scalia. As I said, in 90 or 95% of the cases, it really doesn't make a difference whether it's a so-called moderate Democratic appointee or more progressive. The result would be the same. And why do I say that there shouldn't even be hearings? I mean, why not kind of start the process as a courtesy or something? Because what is the point of having hearings if the end goal is to vote down or not to have a vote? What is the point of holding a vote if your stated position is we'll vote them down, again, not because of anything we learned from the hearing or anything about the qualifications of the judge, but just for the same reason. It seems more honest, it seems cleaner to stake out your position at the beginning and hold to that. And in support of this, here are some statements from leading Senate Republicans. Here's Senate Majority Leader Mitch McConnell. Should a justice resign and the president move to name a successor, Senate consideration of a nominee under these circumstances is not fair to the president, the nominee, or the Senate itself. Judiciary Committee Chairman Chuck Grassley said, it's my view that if a Supreme Court justice resigns, the president should consider following the practice of a majority of his predecessors and not name a nominee until after the November election is completed. Orrin Hatch, the president pro tem, meaning the most senior senator on the majority, has been in the Senate the longest, says, it's my view that if the president goes the way of Presidents Fillmore and Johnson and presses an election year nomination, the Senate Judiciary Committee should seriously consider not scheduling confirmation hearings until after the campaign season is over. Senator Cruz, presidential candidate, also on the Judiciary Committee, says it will be our pragmatic conclusion that once the political season is underway, action on a Supreme Court nomination must be put off until after the election campaign is over. And Senator Lee, very principled constitutionalist, sometimes mentioned as a potential Supreme Court nominee himself in a Republican administration, said that others may fret that this approach will leave the court with only 8 members for some time, but as I see it, the cost of such a result, the need to re-argue 3 or 4 cases that will divide the justices, are quite minor compared to the cost that a nominee, the president, the Senate, and the nation would have to pay for what assuredly would be a bitter fight, no matter how good a person is nominated by the president. Oh, you know what? I'm so sorry. I got my notes mixed up. All of those were actually statements from Joe Biden. When he was Judiciary Committee Chairman, Pat Leahy, now the ranking member, denied a hearing to 60 nominees in less than 4 years under George W. Bush. All lower court, not Supreme Court, but principle holds. In probably the only time I've ever agreed with Harry Reid, here's what Senator Reid said in May 2005. The duties of the U.S. Senate are set forth in the Constitution. Nowhere in that document does it say that the Senate has a duty to give presidential nominees a vote. It says that appointments shall be made with the advice and consent of the Senate. That's very different than saying that every nominee receives a vote. Or Chuck Schumer, who said the following in July of 2007, which in the equivalent for this cycle would have been July of last year. How do we apply the lessons we learned from Roberts and Alito to the next nominee? If there's another vacancy for the rest of this president's term, and if there's another Republican elected with the same selection criteria, let me say this. We should reverse the presumption of confirmation. The Supreme Court is dangerously out of balance. etc., etc. I will recommend to my colleagues that we should not confirm a Supreme Court nominee except in extraordinary circumstances. Dick Durbin, senator from Illinois, who's on the Judiciary Committee, said that the plain text of the Constitution requires a fair hearing and timely vote. As I've explained, this is simply not true. The Constitution leaves to the judgment of each branch how to exercise their powers, and the voters can evaluate whether they're acting wisely or fairly or whatever else. Barbara Boxer, senator from California, said that deferring the confirmation process would be an abomination, and that the advice and consent rule doesn't change with the party of the president. And yet she voted 25 times to filibuster Republican judicial nominees, including to the Supreme Court, not only deferring the process, but preventing it from taking place. She was joined in those filibusters by Senators Reid, Durbin, Murphy, and Schumer. Joe Biden himself, I read his quote, that was when he was the Judiciary Committee chairman way back when, voted 29 times to filibuster Republican judicial nominees. President Obama himself voted to prevent any vote for Justice Alito. He now says that he regrets that vote. That's great. The claim that the president is elected for 4 years doesn't instruct this situation either. The Senate can do nothing to interfere with the president's ability to nominate. But similarly, the president can't dictate to the Senate how to exercise its separate powers of advice and consent. And senators are themselves elected for 6 years. So the country is hopelessly divided. I think it's fair to say, this close to an election, we're only 7 months away at this point. Even if a nominee were confirmed in due course, he or she, whether it be Garland or someone else, would not be sitting to hear cases until the next term starts in October. And as I wrote with Josh Blackman in the Wall Street Journal a month ago, we looked at all the times when there were fewer than 9 justices since the Second World War, and the court gets by just fine. Some cases get affirmed by a 4-4 equal vote. We've seen that this week. Some cases get re-argued. Some of the biggest cases in history have been set for re-argument for this reason. Brown v. Ford, Roe v. Wade, a lot of others. Justice Breyer said a few weeks ago, before there was a nominee, that we keep on working. We don't need 9 justices. Indeed, Justice Scalia's vote would only, last term, if you go by last term, would only create a 4-4 situation in 6 cases. So it's generally about under 10 that would either have to be affirmed by an equally divided court or set for re-argument in the future. Of course, the political risk that the Senate runs in pursuing this strategy is that if Hillary were to win, possibly with a Democratic Senate, then she might nominate someone worse. Again, whether someone is quote-unquote worse is only a small handful of cases where that would really be the difference. But also, I think there will be a lot of pressure on her to renominate Merrick Garland in that regard, especially given all the positive things that she and others are saying about him now. And that's why ultimately this election is so important, as both parties struggle not only with trumpets and Sandinistas, but also with this incredible development in an already bizarre campaign. I can just see Nino, as Justice Scalia was known, sitting with St. Peter over some pizza and Chianti and chuckling over the whole predicament. If you believe in democracy, he would say, this is from a speech of his, you put it to the people. Thank you.
We have a nice amount of time for questions.
The latest news that I saw was that 4 of the Republican senators are now willing to meet with Garland, so I think they're slipping away.
Well, meetings, I don't mind. In fact, if you want to extend a courtesy, I think that's a courtesy. Most of these meetings, I think there was one that lasted less than half an hour today, just to explain to the nominee, saying, we appreciate you, we understand you're in a tough spot, we commiserate this train wreck that you've got yourself involved in, but you can't do it. Orrin Hatch himself, who said very nice things about Garland in the past, has said, to that effect, it's nothing about this judge. Some others have even said that in a normal situation, he would be confirmed without relative problems, which is probably the case. But this is an abnormal situation. So, it might even, when people are saying, well, it's rude not to even have hearings or not to consider the nominee. It might be rude not to meet with him. I think the case could be made that these aren't actually called courtesy visits. It's not a legal term, but that's what they kind of come to be known as. You'll go to the Hill and you have courtesy visits with as many senators as will meet with you. So that's perfectly fine. But those I don't really see as cracks. We see more senators, saying the same sorts of things that Mark Kirk and Susan Collins have been saying, that those would be cracks. Yeah.
You mentioned that Scalia took the view that in a democracy you rely on the people. So there are polls which show that the great majority of Americans would like the Senate to carry out what they think is its constitutional duty. Where do you come down on that?
You can get whatever result in the poll based on how you ask the question. I mean, if you ask people, would you like Justice Scalia's replacement to be like him or unlike him, then like him wins pretty handily. Most people can't even name a Supreme Court justice. Scalia is probably number one, but it just depends on how it's phrased. Some people would say, some of those polls are saying, well, yeah, let's have hearings but not votes, which again seems less principled to me. The ultimate poll is the election, and if that holds up, and if the polls are showing that the senators are being blamed, well, then we'll see Chuck Grassley lose his re-election in Iowa. He's running for his 6th or 7th term. I think Iowa is not a very red state; it's kind of a swing state. We'll see what happens with him. We'll see what happens with the other senators. Although some of that, you might, if Trump is the nominee, you might not be able to disaggregate from that event. But the polls just, when people can't identify the Supreme Court or anything like that, I don't put much stock on those questions.
Thanks for your talk. So as you said, Justice Scalia was an originalist, and he always said, well, once you're an originalist, basically everything's easy. All you got to do is look at the text. And you've got all these people marauding, just making things up. And they just stick with the text, and it'll all be straightforward. But then the examples you yourself gave show that it isn't that straightforward. The bicentennial consent to the Senate, equal protection of the laws, no pre-existing meaning of the law, extremely abstract phrase. I got some views about what's equal, you've got some views about what's equal. So I don't see how one can accept both of these things, that the great constitutional clauses are abstract, vague, very short and detailed, but also buy into the official Justice Scalia ideology. Being a Supreme Court justice is easy, it's just applying to text.
Well, I don't think it's, he said that as kind of throwaway lines, but if it was that easy, we could just program a computer to do it. And a lot of the constitutional text is not explicit. I don't think Scalia was the most faithful originalist. Even on the court, as I said, Justice Thomas was more faithful in many respects. But I think we've gone away. The reason why we have these battles is because partly over unenumerated rights and partly over this doctrine, this artifice that the courts have created over the years, where somehow in-state non-commerce can be regulable. And we're left debating about, okay, well, the government can regulate plants that you grow in your backyard for your own consumption, but can it force you to buy that plant or something? Trying to make distinctions like that, which, if you look at the original Constitution, it's like, well, growing plants is not commerce. It's also not interstate. Case closed. You can't regulate that. Or with unenumerated rights, you're supposed to live in a sea of liberty with islands of authority. And so, even though the right to wear a red hat is nowhere specified in the Constitution, I think it's just as protected as the right to get on a soapbox and talk about your favorite candidate. We've lost sight of that, and Scalia, I think, both in terms of his undue deference to the states and to the administrative branch, I think, went away from that. Those are my disagreements with him, but I think that's originalists disagreeing. And as I said, in Heller, there were vehement disagreements, but they were both arguing on the same terrain. So there are disagreements and there are disagreements.
I have heard it said multiple times that the longer a Supreme Court justice remains in Washington, D.C., the more he or she is inclined to defer to the other branches of the federal government, and the less inclined he or she is to recognize individual rights. In your work, do you see any concrete evidence to back that up?
Well, I've often heard it said that justices, quote unquote, evolve in office, meaning moving to the left. And that used to happen because justices were appointed for political reasons. I don't mean jurisprudential politics, that is, someone who's conservative will have an originalist take versus someone who's appointed by a Democrat will have a liberal constitutional take or something. But people whose jurisprudence wasn't well defined, David Souter, for example, or Bill Brennan before him, at a time where kind of competing legal theories weren't really sketched out. There was no, as I said, rigor to this whole discussion as much. I don't know about deference to federal government or away from states or against individual rights. I don't know about movements in that regard, but I don't think we'll have those kinds of evolutions again. I don't think, given what the Supreme Court has become, given the legal experts that surround both parties now, I don't think you're going to have mistakes, quote unquote, of that kind from either party going forward. And John Roberts, by the way, is not an example of a mistake or someone who's moved left or anything like that. The reason why John Roberts approved ultimately Obamacare twice, once on constitutional, once on statutory grounds, is because he is what conservatives have long wanted, someone who believes in judicial restraint. I think that's the wrong question to ask, whether judges are being restrained, whether they're bending over backwards to uphold something or striking it down. The question is, what is your interpretive theory? And then, let the chips fall where they may, whether that means striking down or upholding the law. And here you have conservative judicial pacifism, if you will, coming home to roost. There are other reasons as well, kind of institutional concerns that we have that are also non-legal, but I think we do need to get away from responding to what we don't like with calls that that's judicial activism and therefore we need more deference and restraint from our judges. No, we don't. We just want judges, I want a judge who agrees with me and my legal theories. Again, that's what everyone should, that's what a president should want. Not, yes, I will sit on my hands unless the Constitution is absolutely clear that I can do something. Yeah.
So, do you think that the whole Bork era kind of really solidified the political nature of these Supreme Court appointments? And do you think it's possible that we could move beyond kind of the inflating nature of these appointments if the legislature actually did their proper job and the executive branch weren't constantly overreaching? I mean, that would be my hope. I would like to see someone kind of burst the bubble and not rely on everything to be decided by these pseudo-geniuses if in fact the legislature didn't pass such a poor bill like the Affordable Care Act. We would have had to rely on
Roberts Care?
Huh?
Roberts Care?
Yeah, whatever. I mean, but what was that like the initial? Is
Right.
that what you see that as a big giant crack and where everybody is just fled to different sides?
The Bork fiasco in 1987 really was the first modern confirmation hearing. That is the kind of embattled nature where both sides line up. Bork was partly responsible for that because he did not well, he had no model to work from, but he refused to play any sort of games. Now, you know how you survive the judicial confirmation, or any confirmation hearing for that matter. You talk a lot and say nothing. That is what you do. It's a lawyerly skill, of course. So, these appointees generally are going to be good at it. But, you look at the Alito hearings, you look at the Kagan hearings, you look at the Sotomayor hearings, they all are saying essentially the same thing. Their judicial opinions are slightly different, but it's not, Bork was actively arguing with the senators and just refusing to take any advice from the White House Sherpa, as it were. This is someone who's been trying to guide the nominee through a hearing. He wouldn't shave his beard. Like, part of it was like he looked weird. This matters in the modern age of TV, right? The year before, Scalia was unanimously confirmed. Okay? The year before Bork. After Bork, Clarence Thomas was its own thing. That kind of the first half of his hearing was one thing, and the second half became the Anita Hill show. HBO is coming out, I think, next month with a mockumentary of sorts on that. I would advise you to take that with a large grain of salt. And then there really weren't problems with Ginsburg and Breyer. Roberts was so smooth. There were votes against him, but Alito, by that point, the Bush administration got so politicized that there were senators voting to filibuster Alito, which is new. But yeah, it goes back to Bork for that. But the real root, as I mentioned, is the constitutional corruption that started in 1937. And so it's not that kind of more honorable senators on the Judiciary Committee with a more spirit of making their institution looking good to the public. It's not that will change this. It's the court itself being more faithful to our constitutional roots. Because look, I really can't blame the senators. Because if your view is that, nominee X, if he gets on the court, that means all of my preferred agenda is going to be struck down. That's a pretty big deal. And if roughly half the country agrees with that agenda, that's a pretty big deal. And vice versa. So, the senators are being politicians. You really can't blame them for that. They're responding quite logically. I mean, you can debate about tactics. Should you do this in committee or do this in the hearing or have this vote or filibuster or not, or discharge this, all of these kind of procedural minutiae. But at the end of the day, the question of whether that person gets on the court or not, I mean, that's a big deal. Especially when it has the potential of changing the direction of the court, where it's, so if it hadn't been Bork, it would have been someone else. The other kind of unusual thing about the Bork thing was that it became so personal and slanderous, which didn't necessarily see, and you saw it a bit with Thomas with the Hill thing, but otherwise, this is just devolved into politics. Not again because the justices vote on political lines, but because their interpretive methodologies correlate to political lines, unfortunately. So there's no easy way out. It took us decades to have the constitutional corruption to the point where we are now. It's not going to be solved overnight.
I'm making calls on behalf of Ted Cruz, and I work from a list, and this week I'm calling people in Wisconsin. And I assumed that I was calling people friendly to the cause. Republicans, unaffiliated, libertarians. Well, not so. Last night, as I began getting more people hanging up on me, and I have a very friendly voice, I'm not offensive at all. Last night, I ran into something I had not run into. And that is when I finished my short spiel, this man said he attacked me verbally about Garland and why the Republicans were doing this, and everything that I said to him, he objected to, and he got He got more agitated as our call went on, and I realized I was going to have to end it. Now, so my question to you is, it did end on a friendly note, but I sort of had to, be sort of a referee for myself. Okay. If you were faced with such a call, and he did say, I'm a bit Democrat, what would you say? I used a lot of the points in brief that you have talked about. What would you say? Now be careful because you may be on my next script.
Virginia's already had its primary. When you get someone of the other party, I don't know why you might want to talk to the Bush campaign of why they're calling Democrats.
Well, it's a pact. I'm calling a pact,
Okay.
but it's a good one.
Yeah. I mean, look, you say it's ultimately a political argument. This is about the election, it's about the direction of the court, and I understand your position. But it's not about the judge. Now, would you rather them hold a kabuki theater charade of a hearing and then decide not to have a vote, or to vote it down for no particular reason, other than that, the same reason for why they're not going to have the hearings now? I mean, ultimately, if the person is not going to be satisfied unless Garland is confirmed, then there's really not much you can say. Again, I mean, I don't know how this polls, but if you gave people a choice, would there be any difference? If the ultimate result is always going to be the same, would you prefer there still be hearings, there still be votes, there still be this? Would it matter to you? I don't know. To me, I just think it would be a waste of resources and, frankly, disrespectful to the nominee to have them go through kind of a stillborn process. In any other circumstance, I think he'd be confirmed. Even though I've listed my problems with him, I think he'd be confirmed fairly straightforwardly. But some people you agree to disagree, and I'm glad that your call ended in a pleasant manner.
So what do the Republicans want to get on the Supreme Court? And then the other thing is, if it were Republican now, I'm assuming that you think the same thing, that if there were a Republican president right now, that we should wait until then.
Yeah, I mean, I think if it's the same scenario, let's say in the last year of Bush's term, Ginsburg passed away or something, I think Democrats would have been. I don't blame Chuck Schumer for what he said in 2000. Well, July 2007 is a little early, but at this point in the cycle, 7 months away from the election, I think it's a fair point. Although I guess the replacing Scalia would mean that Kennedy would no longer be the swing vote in that direction. So there's a bit, but anyhow, it's a political argument in that respect. What was the first part of your question? Sorry.
Who did the Republicans?
Oh, who did the problem? Right. So it depends who you ask. Me as a Cato libertarian, I have my own list. There's other people that would, Ted Cruz would approach the question differently than John Kasich, differently than Marco Rubio, Donald Trump, who knows? His horse? Although when he was asked at that one debate, he did come up with 2 good answers, because whoever was advising him before that debate on the law did a good job, because Dianne Sykes of the 7th Circuit, Bill Pryor of the 11th Circuit would have to be on any kind of top 10 list. They're very strong intellects and solid judges. Dianne Sykes actually is published in the current issue of the Cato Supreme Court Review. She spoke to us last fall at our Constitution Day conference. Others that I would mention, Steve Colleton, who's a fairly young judge on the 8th Circuit in Iowa. A justice from the Texas Supreme Court, Don Willett. I think we should be looking not just at federal appellate judges, by the way. I think there needs to be some more variety in the court. For that matter, Clint Bolick of the Arizona Supreme Court. He's one of the founders of the Institute for Justice and a long-time officer at the Goldwater Institute, which is a free market think tank in Phoenix. He just became a state Supreme Court justice in January. Mike Lee, I mentioned, senator from Utah. That's half a dozen right there. If age were no consideration, again, you have to look at the political scenario. If it's a Republican president with a Republican Senate, let alone a filibuster-proof Republican Senate, that's one thing. If it's a Democratic Senate, it's another. An interesting pick would be Janice Rogers Brown of the DC Circuit, who is just possibly my favorite judge in the country. She's a black lady. She's very libertarian. But she's on the older things as far as these go. I think she's even older than Garland. She's 63 or 64. So that, ideologically would be easy for the Democrats to oppose. But in terms of their identity politics, it would be very hard. Yet she's older. How does that play in? I don't know. Or for that matter, if age is no object, Alex Kaczynski of the Ninth Circuit, fantastic judge, has given a lot of speeches, fairly libertarian as well, a friend of Cato as well. Or for that matter, Doug Ginsburg, again, he's now in his late 60s, so this is unrealistic, but the world would have been a lot different if Doug Ginsburg, or Bork himself for that matter, had been in that seat rather than Anthony Kennedy. So anyway, there's a bunch of those.
There was a campaign stop at Hillary Clinton, at which one of her questioners said, might you consider appointing Barack Obama to the Supreme Court? Can you see that being something that could happen?
I don't think he'd want it. The question was whether Hillary Clinton would ever appoint Barack Obama to the Supreme Court. I don't think it would ever happen because it's a monastic kind of existence. Why would a former president now want to do that after the power he's had and globe-trotting and all, he can have his foundation and make speeches and do whatever he wants, really. Why would he want to do this kind of often very difficult technical lawyerly work? So it's kind of funny. Joe Biden also is a lawyer. He's older, of course, so the age thing comes into there. So there are certainly potential politicians that Hillary Clinton could appoint. Kamala Harris, the Attorney General, soon-to-be Senator from California, or Amy Klobuchar, Senator from Minnesota, although that would set up a big fight for that Senate seat, so political reasons might be less likely. But I do think in future we'll see both sides look at politicians that are probably not ex-presidents. I don't think we'll ever see a William Howard Taft again, who was a very effective Chief Justice after he served as one term.
Quick question. I heard you use the word overreach, and I've been hearing it more and more in political speech and in questioning. Is there some agreed upon meaning of the word overreach?
Well, it just means going beyond your authority, whether it's statutory or constitutional. And I guess the term is used a lot because at some point somebody did a focus group and it polled well, and then it starts filtering in as the buzzwords.
Are you familiar with George Will's recent piece about why there should be hearings, and can you comment on it?
The question was George Will's recent column, basically disagreeing with me about the having hearings and so forth. I exchanged emails with George Will. I sent him my op-ed that I had in the Washington Examiner, I think the day before his ran or something like that. And we just agreed. I think the subject line in my email to him was, "For once, I disagree with you." And we had a very civil exchange. And his general point is that it's not very gentlemanly, it's not very senatorial. We're just not considering anyone at all. But again, I just, forgetting kind of the political calculus, I think if your goal is not to confirm this person, then I think it's more honest to do this than to eventually vote him down while still saying it's not you, it's the institution. I think that would really do more harm in the long term. We'll see. I mean, again, I'm surprised that the Republicans have stuck to where they are for 2 weeks after the nominee was announced. At this point, maybe some polls would shake them. If in October it looks very clear like Hillary will win, But then even then, why would they do it before the election? They would do it in the lame duck. Because I doubt that Obama would withdraw Garland's nomination. That's a separate question of whether Clinton would renominate him. Then, of course, you have the question of the new Senate, because, of course, the new Senate takes office in January 3rd, while Obama's still in office until January 20th. So there are some interesting counterfactuals to consider in that regard. But anyway, you know, again, the argument I'm making on that point is my political judgment. And luckily, I can somehow make a living as a legal commentator, so take my political judgment for what you will.
Even if Obama were to withdraw as the nominee, what keeps the Senate from confirming it anyway?
Right. There are some, you know, I've been on some listservs where some experts in Senate parliamentary procedure are saying that, well, the Senate now actually has jurisdiction over the nomination, so it's more common than simply Obama withdrawing. There has to be some sort of procedure or something, and someone can object. In which case, what happens? Is the Senate going to be like filibustering the decision whether to release the jurisdiction over the nomination? And then there's a discharge petition and all these other things. So yeah, there might be. There's even what if he's confirmed, but this is in the lame duck, and Obama refuses or Clinton refuses to sign his commission. Then we're in a Marbury versus Madison situation. That foundational case in constitutional law from 1803 was precisely about judicial commissions, not the Supreme Court of Justice of the Peace, but still, the new president did not want to have delivered the old commissions. This would be a similar case. Highly unlikely, but anyone wants to write a novel about that or a funny op-ed or something, go ahead.
So a major requirement being Supreme Court justice to back big business and various disputes.
Is a major requirement to be a justice that you back big business? I don't think so. This court generally, you know, without regard to conservative, liberal, or which president appointed them, is pretty business friendly. But that's because the sorts of cases that they've been taking have some sort of outrageous rulings in the lower courts. They're not self-starting institutions. They're not writing the law from a blank slate. You know, John Roberts said at his confirmation hearings that under his theory, if the law says that the big guy should win, then the big guy should win. If the law says the little guy should win, then the little guy should win. So, I don't see any sort of corruption or tilting towards business interests. I mean, I see problems in terms of interpretive theory sometimes, but I don't think it's a matter of, Hillary wouldn't nominate someone, even, obviously from the center left, who isn't already supported by Goldman Sachs or something like that. I don't think that's an issue.
Yeah.
Did I understand you correctly that you thought that this election was about the Supreme Court? How do you justify that in terms of what's going on in the world? The concerns that Americans have about safety and about jobs and all that sort of stuff.
Well, because the future direction of the Supreme Court depends on this election. It's kind of that the question answers itself. So this election is more about the Supreme Court than any election since 1916 or whatever the case was. And so,
but doesn't national security count?
Absolutely. Absolutely. I mean, it would be curious to see if there are people who think that one candidate would be better on national security, the other would be better on judges, or vice versa, or on creating jobs. Of course, it's not the president's job to create jobs; it's the president's job to oversee the regulatory apparatus to get out of the way to let entrepreneurs create jobs. Sure. I would like to meet that voter or see that poll of how many people actually do eventually disagree about who would be better on one or the other of those issues. But as we'll see in the general election campaign, assuming that there is no confirmation, the Supreme Court will play a role like it hasn't, like people like me have always said every 4 years, you know, we need to talk about judicial nominations.
Let me take the prerogative to ask the last question. We're just about out of time.
I might take the prerogative to dodge that, but.
Well, you can't, because you mentioned this administrative law several times. And isn't this the issue that's kind of snuck up on us lately? Administrative laws everywhere. Universities were kind of transfixed, amazed by this Title IX stuff. There are not statutes, not regulations, but letters that the administrative agency writes. And the universities try to play along. And then they get sued by their own students for playing along. What's going on with administrative law?
Even one of the episodes of the rewriting of Obamacare in 2014 was by blog post. So it's not just even letters, or guidances, or whatever. Even the justices have been seeing how these doctrines about deferring to the agency about the interpretation of the law, or even deferring to the agency about the scope of its own jurisdiction, has gone too far. And so, and both progressives and conservatives have complained about this from time to time. So I think there's a lot of intellectual interest, a lot of scholars are writing about this now. It's one area of law to watch going forward.
All right, Alicia Beer, thank you very much.